Hello friends, I welcome you all to Clat lecture series. This is lecture number 3 of Criminal Law Basic Concepts. I am your mentor Shikhar Gehlot. These classes are sponsored by Sri Jendra Rank Zone. So now we will begin with our part E of the Criminal Law Basic Concepts, that is general exceptions, which ranges from section 76 to 106 of Indian Penal Code. Like I have discussed in the previous chapters, all these sections which we are discussing in the criminal law, basic concepts. These all sections pertain to the Indian Penal Code. Okay, all sections pertain to Indian Penal Code. So general exceptions. Exceptions means freedom. Freedom from applicable of a rule. Freedom from application of a rule or a law. Okay. So now our Indian Penal Code says that whoever commits a crime, he shall be punished adequately and the sentences are prescribed. Okay. But there are certain exceptions as well in the Indian Penal Code itself from section 76 to section 106, which says that in certain situations you will be given an exception and the provisions of Indian Penal Code shall not be made applicable upon you. Okay, that means if one is able to place his case within these foregoing exceptions, then he shall be able to claim exception from exception or freedom from the application of penal provisions of the Indian Penal Code. Indian Penal Code is a act, okay, or a code of India which prescribes, which defines what is a crime and defines various kinds of crimes, and then it also further provides punishment for committing such crimes. Further, it also provides you certain liberties or certain exemptions in case you have committed a crime, then how you will be protected from the operation of Indian Penal Code. Okay. The first one is mistake of fact and mistake of law. It goes from section 76 to section 80. Section 76 and 79. Anyhow, these sections are written here only for illustrative purposes, only for a clear and better understanding. These sections are not relevant for you. What is relevant for your syllabus is the crux or the gist of the matter. Okay, so sections I have mentioned here, though they are not very much relevant, even I may say they are not relevant at all, but the principle and these underlying concepts are relevant for you. So you can ignore the sections in case you want to. So the mistake of facts, which is based on the maxim. See, our everything in our law is based on certain maxims. Like I told you that our law or the global law originated from Latin or Greek countries. Okay, because first attempts to codify laws were made by Napoleon. Okay, Greek or Latin countries. So these maxims are in Latin language, and then we translate them in English, and these maxims are old as old as like 1,000 2,000 year old, but they still hold water and they are still very much applicable today. Ignorantia fecit doth execusit. Ignorantia juris non execusat. This maxim came to us in the class of legal maxim and principles, and we discussed it there. Ignorantia stands for ignorance. Facit is fact. Doth means does. Excuse it is excuse. Ignorance of fact is excused. Ignorance of juris is law. Ignorance of law is non-excused. Okay. So the ultimate meaning of this maxim is ignorance of fact may be excused, but ignorance of law will not be. Okay, so ignorance of fact is excusable, but the word used is may. That means in certain situations, not in pan situations, not in every situation, ignorance of fact will be excused. So, in some case, suppose you have committed a crime, okay, and you are able to prove that there was an ignorance of fact on your part, okay, or someone commits a crime and he places his case in the ignorance of fact, that I was ignorance of this particular fact, then he may be altogether excused from the application of penal law. But if someone ignores the law and he pleads that I did not know the law, then that is not an excuse at all. Section 76 deals with two classes of cases where a person is excused from criminal liability on the grounds of mistake of fact. Now there are two classes on which, on the ground of fact, a person is excused when he has committed a crime. When a person is bound by law to do something and does it. Okay. When a person is bound by law to do something and he does it. When a person believes in good faith, owing to the mistake of fact and not mistake of law, that he is bound to do something and does it. Okay. So section 76 says that when a person is bound by law, okay, to do it and does it in ignorance of a fact, then he may be excused. We can take an example of okay. A police constable is not allowed to raid a house in the absence of a sub inspector. Okay. Now suppose a police party in civil dress, not in uniform, civil clothes, go on to raid a house. Okay. Go on to raid a house. And they believe that they have adequate permissions. Okay, they believe they have required permission for conducting the raid, as well as they have an inspector among them. Okay. Now it turns out that the police party had the requisite permission. Okay, had the requisite permission. But this permission, or I may say search warrant, authorized Inspector Rakesh Kumar to conduct such search. But there are two Rakesh Kumar in such police station. There are two Rakesh Kumar in such police station. And the search warrant reaches to the other Rakesh Kumar. Now the other Rakesh Kumar believes that because search warrant has come to him and he is bound by law to inspect the premises, conduct a raid, and he then assembles a police party and goes on to conduct a raid. Okay, in such case, this person believes in good faith, okay, that I am bound by law and I am acting in the good faith, okay, but there is a mistake of fact, okay, not mistake of law. They have a permission, but there's a mistake of fact that to whom this search warrant has been assigned. This search warrant was assigned to some other Rakesh Kumar who is also an inspector, but some other Rakesh Kumar who is also an inspector went there. So this is a case of mistake of fact. What is the mistake of fact here? That who is the Rakesh Kumar? Or I'll give you another example. A citizen is allowed to detain any person who is a fugitive and offender of law. A person who is a fugitive and offender of law. Now believes Ram believes that there is one person, Shyam. Okay, Shyam has committed a breach of law and ought to be detained before escapes. Okay, now Ram believes that Shyam has committed a breach of law, and as an active citizen, he is duty bound that he should detain this person and hand him over to the police. Okay, now Ram detains Shyam. Suppose for 2 hours he has detained Shyam and called the police party. Police comes after a delay of 2 to 3 hours, and meanwhile, for 2 3 hours, the Shyam has been kept in detention by the Ram. Now, police comes and police says, no, this Shyam is some other Shyam. There is another Shyam who is a proclaimed offender. So you free this Shyam. Now Ram has freed this Shyam. Now this Shyam goes to the court and files a criminal complaint against Ram for illegally detaining him for 2 to 3 hours. That Ram arrested me and kept me in his illegal detention from 2 to 3 hours, and he should be punished and he should give me compensation. Now, in this case, Ram can plead that I was acting in a good faith and I found myself bound by the law as a citizen, that I am bound by the law for the interest of the country and the nation and society, and in good faith I arrested Sham. It is not that I knew that Sham is some other person and I just detained Sham in order to harass him and later on to claim that I did not know. Okay, that he genuinely believes that this is the one Sham which is required by the law, which is a fugitive. Okay, but later on it turned out that it was some other Sham. Okay, this is a mistake of fact. Okay, this is a mistake of fact and no offense arises out of it. Similarly, a person may go to the police station and make a complaint that Ashok Kumar has beaten him, and police goes and brings some other Ashok Kumar. They go and arrest some other Ashok Kumar. But when this Ashok Kumar is brought in front of that person, he says that this is not that Ashok Kumar. Now, in that case, what police will do? Police will leave him. Okay, but he cannot go and file a case against the police saying that police illegally arrested me. This is not the case because police is bound by the law to prevent crimes from happening and to arrest criminals. And they were acting in the good faith that we have received a complaint against one Ashok Kumar and we must now arrest him. We must now arrest this man. So now they go and make an arrest. Okay, now this is a clear case of a mistake of fact. Now, in such situations, he cannot file a case against the police party. Now let's proceed to next part, that is section 77. Read it. Judge, acting judicially or in good faith, believes to be following law. Nothing is an offense for fearlessness and independence of the administration of justice. Okay, ingredients of this section are that act of a judge in discharge of his official duty within his jurisdiction and good faith. Okay, now there is a judge. Okay, now this judge, now there is a judge. A police party reaches to the judge and says that a police contingent reaches the judge and tells him that is a factory is running illegal business. We must search it and warrants be issued for that. Okay, now the law requires that the judge should consult his senior judge. There is no such law right now, but let's assume that the law requires a judge to follow a particular procedure. Okay, the law requires judge to follow a procedure before issuing a warrant, but judge in case of urgency is not able to follow the procedure and issues warrants without such procedure. Okay, now tomorrow this police party goes and makes a raid and they conduct a search. Suppose nothing comes out of that particular factory, and the particular factory person says that because of the actions of the police party, I have now been defamed, I have been insulted in my neighborhood, and people look at me with a suspicious eye. And nothing was found out from my factory, and even the warrant which was issued for conducting search is an illegal warrant. Okay, is an illegal warrant. Now, in this case, there can be no criminal complaint against the judge. That judge has issued a warrant in an illegal manner. Okay, he was required to follow a particular procedure, and he thought that the matter is an urgent matter. So he did not follow the procedure and straight away issued a search warrant. Now, what judge was doing? He was a judge and he was discharging his official duty. He is tasked with his power to issue search warrants. Yes, he has to follow some procedure, but he did not do it, and that is within his jurisdiction. And he acted in good faith. It is not that judge has some personal enmity with this factory owner and he just wants to harass him. He just wants to show him his power. This is not the case. Okay, in such cases now, no person can reach to the court and say that this judge has illegally hurt me. That would be wrong. Acts done in pursuance of court order. Okay, till the judgment is in force. Once overruled, no protection. Okay, but if in good faith believes court had some jurisdiction. Ingredients: officer exempted provided acting in pursuance of judgment in good faith believe in legality of the order. Now the crux of this particular thing is that certain acts which are done in good faith and in pursuance of a judicial order are protected from penalty. Now Ram is the jailer. Okay, he's a jailer, jail superintendent. There is a judicial order by Sessions Court that Ashok should be put behind the bars for life for committing murder of A. Now there's a person who has committed, this person Ashok has committed the murder of A. Now the court goes for the trial by the Sessions Court, and Session Court says that because Session Court finds him guilty and says Ashok has committed murder of A and he should be sentenced for life. He should be put behind the bars for life. And then he is taken to the jail. And Ram is the jail superintendent. The court order is shown to the Ram, and Ram is asked to keep this man behind the bars for life. Now Ashok appeals. Now, Ashok appeals in the High Court against this order. After 12 years, judgment is set aside. Judgment is set aside means High Court comes to the conclusion that the order given by Session Court is wrong and Ashok has not committed the murder of A. And the Ashok must be set free. Now after 12 years, after 12 years, Ram is set free. Ashok is set free. Now what Ashok does, Ashok goes and files a complaint against Ram that he kept me behind the bars, he kept me inside jail for 12 years. Illegally because the order is now set aside. Now the Ram is protected. He cannot file a case against Ram. Though this person spent 12 good years of his life behind the bars for a judgment which is later on found to be wrong. Which is later on found to be wrong. Now he goes and files a case against Ram, who's a jail superintendent, who kept him behind the bars for 12 years, and as well as against the sessions judge, who ordered, on whose directions this person was kept behind the bars for 12 years. Now these both people are protected. Both these people are protected. There can be no criminal action against these people. Why? Because Section 77 protects a judge in discharge of his duties. Plus Section 78, it protects anyone who is following a court order. Who is following a court order. But only requirement is that these officers, judge as well as the other officers, must have acted in good faith. It should not be the case that when he was sentenced to jail, this judge had certain enmity with Ashok Kumar and out of that enmity, he illegally held him guilty. It should not be the case. It should be that in the discharge of regular duties, judge have to be fearless. They have to be fearless in administration of justice, and they should be independent. Nobody should control them, neither even their own enmity with someone else. They should be guided solely by the rules of law. And nothing else should come in their way. Even if their own ill feelings about someone, they should not come in the way of imparting of justice. Now, section 79, which says immunity to a person for his act. Immunity means protection. Okay, immunity is protection from legal action. Okay, protection from legal action justified by law. Okay, action is justified by law, but he is not one. He is not a person who is bound by law. Okay, he is not a person who is bound by law, but his action is justified by law. Okay, he is not a person who is bound by law. Like in section 76 we discussed, a police officer is bound. Okay, to go and arrest someone. But there was another situation which we discussed. Okay, that a citizen is allowed to detain a person. Now, when a citizen is allowed to detain a person, he is not duty bound like a police officer. Police officer is duty bound. He cannot let a criminal go free. But a citizen is not duty bound. It is a moral duty of a citizen that if he is able to apprehend a fugitive, then he can arrest the fugitive. But if he is not able to, then he is not duty bound, because we cannot expect a citizen to put his life at risk in order to arrest a fugitive. Why? Because we have a police for that. It is police's job to arrest him, first of all. Okay, and it is police who is required to put their life on stress for arresting that citizen, for arresting that criminal. But if a citizen sees a criminal who is running from the law, then he can arrest that person and hand him over to the police. But if he does not do that, then there is no action against that person, because a citizen is not legally bound to arrest a criminal. But if he wants to arrest, he can. It's his own choice. So when he arrests a person, okay, when he arrests a criminal thinking him off to be a criminal, okay, but it turns out that he is not a criminal, then his actions are justified by law. Okay, his actions are justified by law. Or suppose he arrests a criminal and hands him over to the police, and that criminal files a case against a citizen, saying that this citizen should not have arrested me. Why did he arrest me? If I had committed a crime, it was police who should have arrested me. Why this citizen arrested me? Okay, no, this kind of case cannot be against a citizen. Why? Because he can plead his case that I was justified by the law when I did so. Or by mistake of fact, in good faith, believes to be justified by law. Okay, act of a judge. Okay, when judge does something in the mistake of fact, okay, then he is also protected. Like judge has to order the arrest of Ashok Kumar and there are two Ashok Kumars. Okay, unknowingly he has written the different Ashok Kumar's patronage. The father's name is different. Okay, and wrongly other father's name is written and the other Ashok Kumar is arrested. Okay, these are such situations in which you are excused from the operation of the law. There is no penalty upon you people, okay, or someone who is acting in such behalf. There will not be any case on him. Then we go to section 80 that talks about accidents. Okay. What is the accident? Okay, and what this section 80 says? Section 80 says acts done by accident. Okay, without criminal intent. In doing a lawful act in a lawful manner, proper care and caution has been taken. There is no negligence on your part. You are exempted. Okay, you are exempted. a surgeon is carrying on an operation. Surgeon is carrying on an operation. Excuse me. Surgeon is carrying on an operation, and during operation, the generator hospital catches fire due to nearby electric short circuit. There is a short circuit on the wire nearby, and the flames from that short circuit fell on the generator of the hospital, and generator also caught fire. And due to this small blast, the electricity of the hospital is gone. Okay, for 3 to 4 minutes, and within that span, emergency machines shut down and patient died. Now this is a case of accident. Okay, this is a case of accident. There is no fault from anyone. Now surgeon has no ill intention here. Surgeon is not having any criminal intention to kill this person through following this particular facade. Now what happens? He is conducting an operation. Operation is a critical operation. Okay, there is no electricity in the city. That portion electricity is gone, but hospital is having its own generator which is supplying electricity, and the generator is fully functional and a good generator. But suddenly what happens? There is somehow a electric circuit, short circuit nearby, and the flames somehow reach this generator, and generator also blasts off. Now when generator blasts off, then the electric facility of the hospital is terminated for 3 to 5 minutes, and within that time the surgeon tries his best to save this man but could not save him. Why? Because he was on the emergency machines such as ventilator, which is now shut down, and this person dies. Now in this case we cannot file a case against the hospital or the surgeon. Why? Because they were acting in a lawful manner. They were doing a lawful act. A surgeon is doing a lawful act. He is allowed to conduct surgery. He was doing it in the lawful manner. He was conducting in the environment of the hospital. He was having all the facilities. Proper care and caution were taken. Okay, he had proper equipments, generator, but somehow something happened. Okay, and the electricity is gone and the patient dies. Now in this case, we cannot hold a surgeon guilty. Or I or Ashok is driving carefully on the road. Suddenly, out of the bushes, a child comes rushing and hits the car. Child is injured. Now, in this case, Ashok is driving carefully. He is following all the proper care and caution. His vehicle is also fit. There is nothing wrong with the brakes or something else of the vehicle. Ashok is also sober. He is also not a drunken man. He is driving within the speed limits. He has a driving license as well. Everything is good. He is following all the law. But somehow there are grasses nearby the road, and somehow out of a sudden, a child of 12 to 13 years somehow who is playing cricket in the nearby park comes rushing to catch a ball. Okay, he is trying to take a catch. He comes rushing and hits the car, and he is now injured. Now this is a case of pure accident. Okay, Ashok is not negligent here. The child was negligent. Okay, so this is a case of pure accident, and in such cases, we definitely cannot put Ashok behind the bars for committing a crime which he has not committed at all. Okay, because it was pure accident. Event occurs. Now, what is accident? The definition of accident we must understand. Event occurs without one's knowledge and beyond expectation. Okay, the one who's meeting an accident is not aware, okay, that such thing would happen. Okay, and it is beyond the expectation. Okay, nobody expects when Ashok was traveling. Okay, he never expected that out of a sudden some child would come rushing and would hit his car. Okay, nobody expected this. Or when the surgeon was conducting an operation, he never expected that suddenly something like this would happen and there would be a blast, and due to that blast, this patient would die. Okay, so nobody expected that. Nobody had the knowledge of this. Okay, neither Ashok had a knowledge or the surgeon had a knowledge that this thing will happen, and it all happened beyond expectation. Okay, even if accident takes place while performing an unlawful act, Section 80 would be available if there is no causal connection between the resultant harm and act in question. Okay, even if you are doing something unlawful, okay, even if you are doing something unlawful and then also accident happens, then also you are prevented from that injury, from that prosecution. Let's take a case. I discuss a famous case. Navjot Singh Sidhu. Now, in his young age, what he did, he picked a fight with a man over a trivial issue. Okay, there was a small issue, and Navjot Singh Sidhu, who's a famous cricketer, you must all know, famous Indian cricketer, now a minister in Punjab. He picked a fight with a man over a trivial issue. Okay, there was a fight between Navjot Sidhu and another man. Sidhu punched him thrice. During the fight, there was a fist fight. He punched Sidhu and Sidhu punched him back. Sidhu landed him 3 punches. He punched him thrice. The man dies. The man dies. Now the people said, or the police said, that Sidhu should be prosecuted for murdering the man, or at least killing the man. Okay. Now there's a difference between killing a man and a murder of a man. We'll discuss it later on. But police said that Sidhu should be tried for murdering man and or killing a man. Okay. But when the case reached to the Supreme Court said that yes, Sidhu's act was illegal. When you are fighting with someone, you are not allowed to fight. You are not allowed to take the law in your hands. If you have some issue, then you can definitely reach the court or the authorities, police authorities. Sidhu did not do that. Sidhu unlawfully started fighting. Okay, when Sidhu unlawfully picked a fight, then all his actions become unlawful. Now he gives 3 punches to the man and he dies. Now Supreme Court says that this is a case of accident. Okay, this is a pure case of accident because event occurs without one's knowledge. When in a fight, Sidhu is giving 2-3 punches to other person. He is having no knowledge that the person is so weak that within for 3 punches he will die. And it was beyond expectation. Okay, it was beyond expectation. You usually do not expect that by giving 2 to 3 punches only, some person would die. Okay, you never expect that to happen. That if I'll give some punches, 2 to 3 punches, the other person would die. We usually expect all people to be reasonably healthy, and 2 to 3 punches is nothing. So, what happened ultimately? Supreme Court held Sidhu guilty only for punching the man. Only for punching the man, not for killing the man. Okay, because that has happened as an accident. Okay, that has happened as an accident and nothing else. Okay, it is a pure case of accident. So, in pure cases of accident, even if what you are doing is unlawful, okay, even if what you are doing is unlawful, you are prevented. Sorry, you are protected. There is an immunity that unnecessary prosecution will not lie against you. Okay, this is a case of accident, or we can see in cricket, like we discussed the example of cricket. Okay, we discussed this example very frequently, that a bouncer throws a bouncer towards a cricketer and he dies. Now, in this case, this event has occurred without one's knowledge. He did not know that when I throw a bouncer, this cricketer will not be able to dodge the bouncer or will not be able to play the bouncer or miss the bouncer. He will hit, the ball will directly hit the player on the head. Plus, this is beyond expectation. We all know that a leather ball, okay, which is a leather ball which is going on a speed of 150 km per hour, if it hits someone's head, the person can reasonably die. We can reasonably expect that the person will die. Okay, but here this is beyond expectation. Why? Because cricketers wear a protective gear. So when this cricketer was playing a game, he was wearing a protective gear. Okay, he was wearing a protective gear. A helmet was there. So nobody expects that helmet is put in place in order to save someone. Nobody expects that when I will throw a ball, somebody else would die in such unfashionable manner. Okay, so this is also a case of an accident. Or take the case of a shot put thrower or a javelin thrower. Javelin throw. Okay, javelin throw is a spike. It's a sport in which it's a spike. Okay, and you throw it. Okay, you throw it. The one who is able to throw it at the maximum distance emerges as victorious. It's a pure show of strength. So Ashok is a player of javelin. Okay, javelin throw. So now in a stadium, he throws a javelin and it accidentally hits the referee in chest. Referee dies on spot. The referee dies on the spot. So now in this case, this referee who has died on the spot, now this person who has thrown the javelin, he is not liable for killing the referee. Why? Because it's a case of pure expectation. When he is throwing a javelin, he has no knowledge that the javelin will get out of his hand, will slip out of his hand. Okay, he has no knowledge that the javelin will slip out of his hand. And even if it slips out of his hand, okay, then there is a big broad field, but it will ultimately only go to the referee's chest. This is not expected that this is a vacant ground. I am throwing a javelin. Even if javelin slips from my hand, it will fall from somewhere. But this is beyond expected that it will ultimately fall in the chest of. It will ultimately pierce the chest of the referee, and referee dies. Now these are the cases of accident. So when an accident is committed, that means it's a pure accident. Nobody has done anything. Any damage may have happened, but it is accident, so we cannot hold anyone liable for accident. Accident is an accident. We can simply say accident was the will of the God, or God wanted this thing to happen, so it happened. Okay, like we usually say. So we have covered both the cases, okay, in which you illegally are doing something. Okay, your act is illegal. Like in Navjot Singh Sidhu picked a fight. His act was illegal, but accident took place during an illegal act. Okay, then also he is protected even when he was doing unlawful act in an unlawful manner. Then also, if an accident happens, he will be protected. Okay, and cases in which accident is happening while doing a lawful act in a lawful manner. So cases like these are protected by the law. Okay, so meanwhile, only this in today's class, and then we will assemble for the next lecture in the next class. Thank you.